Hi everyone, this is Dr. Victoria Nolly, and here with me is Dr. Carol Nakla and Mr. Peter Mulisa from the Uganda Petroleum, from the Uganda National Oil Company. So we're supposed to be joined by Professor Peter Cameron, but he will not be able to make it today. But however, I note in our last webinar discussing the same subject, Professor Cameron was able to present. So in today's webinar, this is just a continuation of the last discussion we had. So it will be a very short webinar because we already discussed most of the things. And in this respect, we shall only use 50 minutes. And Mr. Peter Mulisa will start off with the discussion, and then Dr. Carol Nakla will come in and also make my presentation. And then there afterwards, we can take in the questions. Feel free to send in your questions anytime. Use the Q&A to send in questions. And also we shall take up questions later on. So before we start, I'd like our presenters to briefly introduce themselves. I'll start with Dr. Carol Nakla to briefly introduce herself, and there afterwards, Peter will also introduce himself.
Thank you, Dr. Victoria. I'm Carol Nakli. I'm the CEO of Crystal Energy and the founder and director of Access Wind and Energy. I'm an energy economist by background, and I've been in this business for more than 20 years. And one of the areas I focus on is contractual stabilization, particularly fiscal stabilization provisions. And I'm sure we're going to have a very lively discussion in the next 50 minutes or so.
All right, thank you very much for the introduction. Mr. Peter Mulisa, would you like to introduce yourself?
Thank you, Victoria, and good to have to see you, Carol. And it's a shame we've missed Professor Cameron today. Good afternoon, everyone from Uganda. My name is Peter Mulisa. I work with the Uganda National Oil Company. I head the Legal and Corporate Affairs Department, and I've spent the last 10 to 11 years dealing and interfacing with the oil and gas sector. And stabilization clauses, arbitration clauses are some of the interesting elements of the work I've been doing in the last 10 years. So I look forward to this conversation. I think it's going to be an interesting one. I apologize, I missed the last one due to inevitable circumstances. But I'm glad I'm here today, and I'll contribute to this conversation. Thank you.
All right, thank you very much, Peter, for the introduction. So we shall start off the discussion with you, Peter, because I know you've done a lot of work in Uganda. I think you are the leading counsel in some of the cases we had with some international oil companies. So I think you'll give us the practical experience with respect to stabilization clauses, and also the fact that you've worked with the government for a very long time. And it places you in a good position to give us the practical insights with respect to stabilization clauses, especially their implication and also the effectiveness in developing countries. So I'll let Peter to start off the discussion, and then there afterwards, Dr. Carol Nakla will come in with her discussion.
Thank you, Victoria. I think I'll dive in, and I do believe that the introductions as to what amounts to stabilization clauses is not necessary, but I'll just run through it just to ensure that everyone is on board. And then, yes, I'll give my experience and how we see it from the side of governments and national oil companies, and whether we believe what future we see for stabilization clauses. So briefly, stabilization clauses, and it's a whole package. It's really all those clauses or provisions or structures that aim at achieving stability of an investment. And most of them sit in contracts between sovereign states and international investors. In the case of oil and gas, it's international oil companies. The stabilization clauses in these contracts aim to achieve mainly one purpose, that governments do not change the agreed terms of the agreement without consent of the other parties. So I think in the past, we had clauses that would freeze the enactment of any law or legislation or other means that would change the agreed positions that is in the agreements, mainly production sharing agreements for oil and gas. This evolved largely now to what is mainly used today, which is called economic rebalancing or equilibrium. Different texts will have it differently. And that generally aims at restoring the entity, the investor, to the position should have been had that investment, had that change not occurred. And so there's a way to calculate the impact on the economics of the company, and usually that provision, that formula and methodology is provided in the clauses to basically ensure that if it is established by the international company that any change in law regulation or interpretation of the law has affected it economically, then a methodology and a process is undertaken to ensure that that entity is put back in the position it should have been in. Now, but that is contractual. Some others come through legislative enactments in countries. I could say in Uganda, we have an investment code act that aims at attracting investment in Uganda, attracting international investment. And it has provisions that stabilize investments of foreigners in Uganda. And so that could be another access. But of course, that has the risk that it is a legislation by a parliament in Uganda that can be undone. The parliament can cancel it, amend it, or repeal it at a certain point. The other, I think, set of protections come through bilateral and multilateral treaties. So this could be BITs or DTAs for tax purposes that still protect investments and provide for avenues of protection. And I think most of the arbitrations that we have today in the sector that between states and entities are largely around bilateral investment treaties, particularly fair and equitable treatment, FET, and some other common clauses in the bilateral investment treaties. And I think as of last time I checked, there were more than 2,600 BITs signed by countries, especially the developing countries. And so why do these entities, these international oil companies and other investors require this kind of stability regime, either contractual, legislative, or by treaty? And it's largely to address risks that they perceive exist, especially in the developing countries, because most developed countries do not make these provisions. And the perception of this risk is largely built around the feeling that in most of our countries, developing countries, as seen by the investors, the rule of law is not really fully established. That perception may be correct or incorrect, but it's what drives this requirement. And the general feeling is that the countries may change their laws and significantly affect the investment parameters, the basis of the investment, which are the economic basis for the investment. And they trust that, they believe most of these countries would take those changes in laws unilaterally. And so these clauses come in to minimize, to mitigate that risk. And of course, the other one, focusing largely on oil and gas, is that oil and gas is highly capital intensive, high risk, and long term. So for that investment to be undertaken, the oil companies need certainty on the return on investment, and the environment must be such that the return on investment is guaranteed, especially if project financing is to be involved. It's quite rare in the upstream, but it does happen in midstream in most of the projects. So the need for certainty requires these stability packages that include stabilization clauses and arbitration clauses that aim at having any disputes arising from these agreements resolved outside the host state judicial system in a structure that is deemed neutral to both parties. So those are really the drivers on the part of investors. On the part of governments, of course, the look is the view is that stabilization clauses, in a way, infringe on the sovereignty or limit the sovereignty of the state to manage its resources, which is, I'm sure you're aware of the UN resolutions in the 60s on the sovereignty of nations on their resources. So there's a general feeling that it limits the sovereignty of the state, as well as the sovereignty of the state to legislate as it deems fit for the benefit of its country, of its people. And the counter argument is that by the states entering these agreements, they are actually exercising that legislative, that sovereign power by giving these stability packages. And that is the argument. And of course, when you go to history, you'll find examples of resource nationalism. You'll find countries coming in to seek renegotiation at the point of production of the resources because they realized maybe they had a bad deal at the beginning. And these are the fears that international oil companies have. I did find a quote by Rex Tillerson when he was still CEO of ExxonMobil. And he indicated that for oil companies, the oil companies are willing to take all manner of risks, except what he called low changing on us risk. So there is a general fear among oil companies and other international investors on the low changing and significantly impacting their investment. But on the part of the government, what these stabilization clauses do is that in addition to the comments I've made on sovereignty being limited and sovereign right to legislate and the challenges of one government committing future governments, there are other elements that come through. And it's not uncommon that parties should be able to, in good faith, renegotiate a contract at a certain point, especially long-term contracts. So you have one fear of the international oil companies being the government forcing on us a renegotiation, but there is a genuine concern also or basis for the states that maybe at the point of signing, say, production sharing agreement, some 3 or 2 decades before, you find that the discoveries are probably larger than anticipated. The oil prices are much better. And so the economics need to be revisited, and the take of the government or the state entities revised upwards. And that is the fear. But of course, the state, if it had a bad bargain, and you have these stability clauses, it is locked in that bad bargain. And so like chicken and egg, that can in itself cause resource nationalism and avoid the stability of the contract and void the stability of the contract for long term. So it becomes key that as entities negotiate, both oil companies and governments, they should aim at achieving contractual positions that are fair and that are stable, that can successfully be sustained through long-term projects. In terms of practice, most agreements that I have seen have stabilization clauses for the entire period of the investment. And this could be up to 40 years of investment. So the kind of conversation that we are looking at and what we think the future should look like is that the aim of this stabilization package, let's call it, which I've explained that is contractual, that could be treaty-based, and that has arbitration and dispute resolution together. the future of these clauses should be such that you look at if you have debt involved, how long is your debt tenure? And how much time do you need in the period of investment to have return on equity? Can we limit stabilization clauses to that period? Because that's a period that could undo the investment. But if we come to have stabilization clause and this whole stability package for the entire duration of the investment, it's probably not sustainable. And it is likely that you have challenges of renegotiation, issues of resource nationalism. So my take on the future of stabilization is that we must look at it with the primary intention of answering the investment needs and risk for the project up to the point of debt repayment and equity returns, that the return on equity that we can agree to. And so in my view of things, you would be looking at probably 10 to 15 years in most projects to ensure that you have debt repaid and you have, excuse me, you have debt repaid and you have a return, a reasonable return on investment. In terms of arbitration, just to touch it for the last few minutes, usually the provisions do subject all claims or disputes that may arise from the contracting issue. And it's usually a foreign city as the seat of arbitration. Applicable laws for the arbitration will probably be for another country. And CITRO or LCIM. And these bodies, I think, in my experience, tend to be professional, impartial, and to do their job very well. And of course, we have other institutions that do arbitration and focusing on states and focusing on state disputes. And it's fair to say that there's a big body of disputes resolved and resolved correctly. There are a few that are questionable. And so the question is, of course, the country, this project sits in this country, and any matters arising from this project should ordinarily be resolved through the court systems of that country. But most of the times, the investors don't trust the court systems to be impartial. And in many ways, they will vividly tell you that we don't trust that the state won't influence the outcome of these disputes. And as such, you end up in the foreign city. So the question for me is, should we have arbitrations on all aspects of the contract? And I think there is a good case for limiting the arbitration clause to a particular aspect of the contract, so that the rest of the issues relating to that particular contract are subjected to the legal regime of the country in which the project is implemented. I also do believe that in the case of arbitration, there is a good case to expand and discuss the question of arbitrability. Is everything under the sun arbitrable? Should we arbitrate tax? Should we arbitrate anti-competition laws and behavior? Should we arbitrate all sorts of things? And this is a question that we should have. I do believe that there are certain elements of writing on this. There are certain elements of provisions on these elements. We have to review what's public policy. Is there an international body of laws or agreement on what public policy, what constitutes public policy? What's public policy in Uganda? What's public policy in Ghana? And should matters of public policy be subjected to arbitration? So I do believe that as we negotiate these agreements, sufficient carve-outs need to be provided. Not everything is arbitrable, and that should be clear in the agreements. I do believe that as for now, we probably will continue having requests and requirements from investors to have these stability packages. But I do submit that we need to start limiting the areas in which they apply and create enough carve-outs to answer the key concerns of the investors, so that the clauses just answer the key concerns of the investors, which is the bankability and the return on investment. But it shouldn't guarantee profitability of the project for 40 years. It's okay for an entity to make profits, but it shouldn't be, it should play like any other investor after a certain period. Because what these stability packages and arbitration clauses will create is that you have one body of investors treated different from another body of investors. And usually it's the body of investors treated different is foreign investors in a country. And that in itself is not a good way to increase investment. In conclusion, I do believe I've read some articles analyzing the impact of bilateral investment treaties on the rate of foreign direct investments. And I think the conclusion in the articles that I have read on BITs is that there is no evidence that countries with BITs receive more FDI than countries that don't have. I would dare say that that applies to stabilization clauses. And I permit me to stop there. I do believe I've exceeded my time. Thank you. I hope this generates the debate that is required. Over to you, Victoria.
Thank you very much, Peter. So before we go to Dr. Karunathla, as usual, let me advertise some books. So this is Carol's book, and she has also written a lot on petroleum taxation. She has an article on stabilization clauses. So you definitely have to get the books. Although Professor Cameron hasn't joined us, but he's a leading expert with respect to international energy investment law, the pursuit of stability. He has a lot of work on stabilization clauses. I think that book is almost about stabilization clauses, BITs, MITs, and so on. And Professor Damilola's book on extractives industry, law in Africa. This would also be good for you. Surprisingly, I don't have a copy of my book. Let me see. Okay, let's see. So for energy transitions in Africa and their impact, this is the book for you, edited by me. And also, if you're interested in energy law, just an introduction, you can look out for Professor Raphael Heffron's book. So enough with advertising. Let's go to Dr. Karunathla. She's going to take us through stabilization clauses, specifically from an economic perspective, because she's the only economist on the panel. So she'll go through the fiscal stabilization clauses, and then I will also come in with my presentation.
Thank you very much, Dr. Victoria. I mean, you always do a wonderful job with webinars, but particularly in promoting your speakers' books. So thank you very much. Not many people do that. I'm glad that Peter spoke first, because that gives me the right platform actually to continue from where he ended, particularly focusing on the issue of specific areas that we need to stabilize in the contracts. And this is where I'm going to highlight a key element, that is a fiscal stabilization, whereby you would stabilize fiscal terms, taxation, royalty, production sharing, profit sharing, cost recovery ceiling, for instance, for either the duration of the contract or for a lesser duration as agreed by the parties. And here I start, with the title, are stabilization provisions in general, are they a must? And I can tell you the answer from now. No, they are not a must. They are used to achieve a certain purpose, which is not always achievable. But for me, it's not about their effectiveness is questionable, as I'm going to show you later on, but they kind of make governments think twice before taking certain measures that are adverse vis-a-vis investors. And before I take you through all the details, I just want you to think, to detach yourself from whether a government is getting a fair share or not, and look at the issue independently and objectively. Just pretend or imagine that you yourself go and undertake a major investment in a country, you reach an agreement with the government, whereby you sign a contract for, say, the next 20 years, you go and you borrow money to invest in that project, you put a lot of effort in that project for several years, and then boom, your project suddenly becomes successful. And then the next thing you find is the government coming knocking on your door and say, excuse me, I want to revise the terms of the contract because I did not envisage that scenario. What will you say? You will say, yes, of course, let's do that. Or will you be reluctant? And even if you accept, would you be keen on investing again in that country, especially if the terms were changed abruptly without any negotiation or at least advance warning? So just take that scenario and then you will understand the investor's perspective when they are committing a lot of capital. We're not talking here about thousands here, thousands there, talking about millions and hundreds of millions of dollars invested upfront in oil and gas projects in different countries. So with that in mind, let me now take you very briefly through the concept of fiscal stabilization. But first of all, we talk about stability of contracts in general. And you can see here in this slide, it's not just the oil companies who advocate for stability. Actually, one of the things I learned when I did my PhD on petroleum fiscal regime is that one of the principles of a good tax system is stability. So it's a principle of an ideal fiscal system, let alone contractual arrangement. But you can see the oil companies call for a stable system, a regime, in this case, the fiscal regime. The IMF, the same, recommends a stable and predictable tax system. I took the UK government example where they also say that our aim is to achieve stability, cement stability and certainty. And more recently, the OECD, when they published their guiding principles for durable extractive contracts, they also advocated to contracts that foster fiscal stability and thereby contribute to the durability of the contract. So it's not coming from the investor's perspective. It is actually in economics textbook, and also it is advocated by international organizations and by governments alike in some places. However, I wish Professor Cameron was with us, but I'm sure Peter will more than fill the gap. But in legal terms, we talk about the pacta sunt servanda, which is a strict sanctity of the contract, and any contracts, they come with that. And it is widely accepted, so we don't have to add further provisions to secure the stability of the contract. But however, I say here that under no legal system, you will find it absolutely respected. So there is always room for renegotiating contracts, particularly oil and gas contracts. First of all, because we're talking about something that can cover a long period of time, several decades. Just think about some oil fields which have been producing for decades now, and they are still in business. And imagine if you signed a contract right before anything was drilled. You don't even know whether you have oil and gas, and then 10 years down the line, you hit a big discovery, prices change drastically. Investment becomes more appealing, so you have more investors coming to your country. So I understand that's very difficult to capture all these potential scenarios. I mean, the pandemic, coronavirus pandemic, right? Which investor, find me an investor who signed a contract before 2020, who was able to foresee this kind of development. So we understand that we cannot capture all the scenarios, but there is a way around minimizing the continuous and endless tinkering of contracts. Because remember, it's not about dealing with one investor. It's not about achieving immediate short-term gains. You have to think about the long term, because
investors, as we say, once bitten, twice shy. So think of Venezuela, for instance, what is happening in Venezuela today. It's not because of what President Maduro did over the last few years, but it goes back to 2005, 2006, when late President Chavez changed the contractual terms abruptly, and companies end up having litigation cases with the government, and other investors simply shied away. So you have to think about the longer term, and you have to think about the bigger picture. So as I say here, one of the things that you have to keep in mind is that even though we advocate stability, oil and gas projects are by their own nature inherently unstable. And here I pinpointed only one area, that is, for example, in terms of sharing the potential rewards from the projects. So you find all around the world, and here I took the case of Alaska and Liberia, and you can see the similarity, a developed economy, a developing economy, and they both say that they want to achieve a fair share of the proceeds. My problem with this term fair is that how do you define it? What is fair? Is 50-50 fair? Is 40-60 fair between share to government or to investors? Or is it 70-30? You see, so we can have endless discussion about what is fair. And more importantly, the definition of what is fair changes with exogenous factors such as the oil price. So when prices were 100, a 60% to the government versus 40% to the investors share of the proceed suddenly became unfair, and governments wanted 80. What about today? Oil prices, where they are today, at least where they were 2020, would you go and revise the terms? So that's why when you want to pursue fairness, you have to bear in mind that it's something that varies from one investor to the other and from one government to the other. And actually, if you put 4 people from the same ministry in one room and ask them to give you a definition of the kind of share that they see fair, you will have 4 different answers. This takes me now to the concept of fiscal stabilization. First of all, stabilization provisions, why do you need them for? So the purpose is to lock in the terms of the contract, either many of them or specific areas for the contract duration, and they can cover a wide range of flows. That's why I fully agree with Peter that I'm not really keen on these blanket provisions that cover everything. For example, environmental taxes or environmental laws or labor laws, they should, in my opinion, they shouldn't figure. They shouldn't be stabilized in a contract because companies, irrespective of the industry they are operating in, they should follow the international legislation as applicable to the rest of the industry, especially when it comes to these areas. But there is one specific area that is highly controversial, but I understand where investors are coming from, and that is the stabilizing the fiscal terms of the contract, and they deal exclusively with taxes and royalties. They may cover the whole of the fiscal regime, or they may cover specific taxes and fees. For example, you would fix the royalty rate for the duration of the contract. A few years ago, I did a research paper with a colleague of mine, formerly with the IMF, and you can download that paper because we looked at a large number of countries in terms of their practice, what kind of fiscal stabilization they adopt. And we found really a very colorful scene, big variation in the terms, big differences in the way they are applied. Some are legislated, others are in the contracts, others are offered in some contracts, but not in others. In some countries, such as Afghanistan, for example, we found that the government would offer to stabilize the corporate income tax, for instance, but investors have to accept to pay a higher rate than, let's say, investors who didn't go for that fiscal stability. So that's why it's very important to keep an open mind when you are talking about fiscal stability, because they come in different colors and shapes, and it's important to read the contracts meticulously to make a learned judgment and not just generalize. Now, why do companies want fiscal stabilization provisions? They would like to neutralize political uncertainties and fiscal risk. So they want to legally bind the governments to the terms of the contract for the duration of the contract. So it's one way of mitigating the risk of governments suddenly deciding to change the terms of the contract in the middle of the investment proposition. And also some lenders view fiscal stabilization provisions as essential for the bankability of the project. Here I took this quote from Johnson, but you can read it again. We talk about mitigating risk. And some companies actually, even those who pursue it aggressively, they know at the end that the sovereign, the government can do whatever they want at the end, but they try to impose a certain good behavior. So when you have the fiscal stabilization provisions, they try to make the government think twice before implementing or introducing fiscal changes. But at the end, we know that governments can do whatever they want. Now, it's not just companies who ask for fiscal stabilization provisions. Some governments do offer them voluntarily. And it's typical in developing countries. And again, it's not about treating developing countries differently from developed countries. And again, we cannot generalize when it comes to developing countries, but you will see that in some countries where you have, for example, a high political and regulatory risk, especially when it's combined with high geological risk, then you want to do something to compensate for this additional risk exposure. So you kind of give this kind of stability provisions. And in my opinion, they can be more superior than tax exemptions, but surely tax holidays. And other governments want to give it to attract capital, and that's how they feel that they achieve what we call tax competition, a higher score in the eyes of investors compared, let's say, to a neighboring country that doesn't offer them. And we also found that they are offered by governments typically in weak bargaining position. But again, it doesn't have to be each one of these. It can be either or, but in general, it is perception of risk in the country. And I would say the reputation of the government, the quality of the institutional framework that you find in the country, that will tell us whether we're likely to see or not fiscal stability provisions. So in countries where you are unlikely to see these kind of stabilization offered, you usually find a history of sound fiscal management, corporate tax rates, which are in line with international rates, low tariff rates, non-distortionary taxes. You don't discriminate between domestic foreign investors, low level of corruption, transparent tax policy, and efficient tax administration. So if you really score high on most of these, then you do have a strong case not to pursue or implement fiscal stabilization provisions. Now, I will not go through this one. I'm going to share with you my presentations just to give you an idea about the wide variation of fiscal stabilization provisions. Some of them can lock in the terms of the fiscal regime for the whole duration of the contract. Others are more acceptable. So the old-fashioned way was called freezing, where everything, all the rates are fixed. Then gradually moved to what we call economic rebalancing. Economic rebalancing does not look at individual tax rates, but it looks at the overall profitability achieved by a project. And it's not that the government has to secure the same profitability every year for the investor, but it simply means that if the government implements fiscal changes that drastically change the economic balancing of the project or the economic outcome of the project, then the governments have to sit down as investors to try to reinstore that balance. So again, the devil is in the detail, and that's why I prefer not to generalize. That said, I want to make one point about this slide and the type of fiscal stabilization provisions. This is what is known, but there are some measures which don't fit under the description of fiscal stabilization provisions in its conventional way, but they are more powerful than fiscal stabilization provisions, such as paid on behalf, where the government decides on national company to pay on behalf of the investors certain taxes, such as the corporate income tax, as we find, for example, in Cyprus. So that could be a stronger measure than officially having a fiscal stabilization provision. Now, in my last few slides, I raise this question: are they sufficient to mitigate political and fiscal risk? First of all, their effectiveness is questionable, and that's what we found, and that's what I continue to experience across the world. Because it's not only about the willingness of the government, but also governments that lack administrative capacities to enforce their fiscal stabilization provisions in the contract, of course, will lead to a different outcome than what investors originally envisaged, and also where governments lack the judiciary and the judiciary lack credibility. So don't expect much enforcement in this respect. And I say here that don't rely on contractual devices to mitigate risk. Sometimes what you find something much more powerful than these stabilization provisions is to simply design the fiscal regime right from the beginning, make it automatically progressive, which means it adjusts to different conditions automatically without any need to go and tinker and change the contract. But unfortunately, I don't know why very few governments take that into consideration. So my recommendation when it comes to fiscal stabilization is that we will continue to see them as a common feature in developing countries as long as the world continue to use oil and gas. However, we don't recommend governments to offer different types of fiscal stabilization if they want to offer to different investors. So they should go for non-discriminatory treatment, and they can be offered at a premium. But at the end, my advice to investors is that don't put too much faith in fiscal stabilization. So with that, I will conclude, and remember something which is more important, that is the institutional framework overall. The bigger picture is more important than simply narrowly focusing on one specific area. Thank you very much.
Thank you very much, Kara. So, because we are running out of time, we're supposed to end at around 12:50. So I'll make my presentation really, really brief, because everything Dr. Karonakla has expounded a lot on fiscal stabilization. And then Peter Mlisa has also taken us through the practical issues and legal issues with respect to stabilization clauses. So my discussion will be really brief. So in my discussion, I'm simply asking a question: what is the problem with stabilization clauses in the 21st century? And the reason as to why I'm asking this question, because I note that these clauses date back as far as 1930 and were mostly used in the 1970s, where countries were nationalizing petroleum projects, but we are no longer in the 1970s. Most developing countries have strong legal and regulatory framework. The rule of law is stable, and most of these countries are also politically stable. So why exactly do we still need stabilization clauses? If in instance we are imitating what is being done in the developed countries such as Norway, Canada, who also are very resource-rich countries, but they don't offer this kind of stabilization clauses. So should we also imitate them in the way we negotiate our contracts? Should we imitate them in the way we negotiate with international oil companies? Why would we have stable legal and regulatory framework? Why should we sign all the BITs, the multinational investment treaties, and still we're being bullied to include stabilization clauses? So that is the question that I want to address. I already talked about myself, but I need to note for our participants, my new Nalole Energy and Mining Consultancy Company, where we are really active in providing consultancy work in different countries, and also the NGO. I'm sure most of you are aware of the MENGO, because we've done lots of voluntary work in different African countries. And also for my books, there are 5 books so far, and there are 2 upcoming, and one is actually going to be an edited book with Professor Damilola. It's an edited book on international arbitration in the energy and mining sectors, where we are really expounding and exploring on issues of arbitration, international arbitration in the African energy and mining sector. And I'll be giving you some of the examples with respect to arbitration and the aspects of state sovereignty in my presentation today. So I'm not going to waste a lot of time on stabilization clauses, because Peter and Carol, they have already explained to you what stabilization clauses are. But in summary, stabilization clauses contractual assurance to investors that the legal and regulatory framework will stay the same in the given period of the project, be it 20 years, sometimes the project take like 40 to 60 years. So it's that assurance that the terms of the contract or the legal and regulatory framework will not be changed during that period in a way that is likely to negatively affect the investors. So that is the essence of stabilization clauses. And there are stabilization clauses of the legal nature or stabilization clauses of a fiscal nature. In my last presentation, I gave you a list of different types of stabilization clauses, including the freezing clauses, economic equilibrium, just to mention a few. So I'll not really go into detail, but I just want to point out some of the examples of stabilization clauses. And I want to draw from an example in Liberia. I'll just read it for you so that for people who are not aware how some of these stabilization clauses, the form they take or the wording they take, because we have to note that we don't have a uniform stabilization clause. They are negotiated differently and different countries offer different stabilization clauses, but then they have the same impact to protect investors, to ensure that the legal and regulatory framework is not changed during the period of the investment. So for the example of Liberia, I'll just read for you. For the avoidance of doubt, any amendments, additions, revisions, modifications, or other changes on the tax corpus made after the amendment effective date shall not be applicable to the concessionaire. Furthermore, any future amendments, additions, revisions, modifications, or other changes to any law other than the tax corpus applicable to the concessionaire or the operations that would have the effect of imposing an addition or higher tax, duty, custom, royalty, or similar charge on the concessionaire will not apply to the concessionaire to the extent it would require a concessionaire to pay such tax, duty, royalty, or charge. So what is the problem with this clause? The problem is it is freezing the Parliament's abilities to enact laws, tax laws that are likely to affect these oil and gas companies. Like I keep mentioning, societies are progressing socially, economically, and politically. And in this respect, governments, especially in developing countries where we have lots of issues, economic issues and poverty, they should be in a position to enact their laws or amend laws to reflect these changes. So if you have a stabilization clause like this example in Liberia, that means that the government cannot do anything. However much the circumstances have changed, obviously, like Dr. Karanakla mentioned, investors are more concerned about protecting their investments, but that doesn't mean that they should protect their investments at the detriment of the host government, at the detriment of the local communities. And this is the reason why we're saying that in most countries, developing countries that have been extracting resources for a very long period of time, they're not benefiting. And we keep asking ourselves, why exactly are these countries not benefiting and yet other countries are benefiting? Obviously, there are many reasons that are being cited by different people: corruption, lack of transparency. But in most cases, we also miss out on some of the contracts we sign, some of the provisions we agree to. And it's my argument that in the 21st century, all developing countries should really, really be careful with the kind of contracts they sign, the kind of provisions they agree to. Because like in this example of Liberia, no state should accept this kind of stabilization clause in the 21st century. This is the example from Tanzania. I'll not read it out because I will be sharing my slides. And also, I think most of you have got my policy brief about the subject, so you know my line of argument. So obviously, the reason as to why international oil companies demand for stabilization clauses is due to the instabilities. And also, like Peter mentioned, petroleum projects are very expensive ventures. They require a lot of capital. So obviously investors should be assured that their investments will be protected. And also the COVID-19 pandemic has shown us that the sector is unstable. It can't be stable at all. So with the instabilities, with the uncertainties, market uncertainties, and also coupled with the unique challenges faced in the petroleum sector, that presents the reasons as to why most international oil companies demand for stabilization clauses. In essence, to tackle the instabilities or to protect themselves from the instabilities that are likely to happen. Then I'll just go to my main question. What is the problem with the stabilization clauses in the 21st century? And the problem is the ambiguity of these clauses. I've just given you a list, a few examples of Liberia and Tanzania, but given the fact that we don't have a uniform way of stabilization clauses, we don't have any uniform stabilization clause we can rely on, even for a country, because each country negotiates different stabilization clauses with different investors. So it's different wording in a different time frame, implying that the country has to keep updating themselves. They have to keep track of whatever is happening. They have to keep track of the laws they're amending to be assured that they will not affect a certain type of investors. Because remember, they don't apply to all investors. So that is the main problem, the lack of uniformity in stabilization clauses. And the other thing is the ambiguity, because most of the stabilization clauses are broadly drafted. And they're broadly drafted not to protect the host governments, but to protect the international oil companies, so that in case you make any mistake, they can always refer the case to arbitration, they can always take you to court and say that you're in breach of the stabilization clause. So the ambiguity of the stabilization clauses is the main problem. And what countries can do mostly, like how, as I'll mention in my next slide, is to limit the time frame and also limit the wording of the stabilization clauses. And then the other issue that really concerns me is the fact that no developed country would offer these stabilization clauses to investors. I've read lots of articles, and one of the author was asking, is it are these countries or are these companies using stabilization clauses as contractual mechanisms? I mean, as a colonial mechanism, because why is it that they are only applied in developing countries? And I note there are some countries that have strong legal and regulatory framework. Their laws are stable, they are politically stable. There are countries that are like the Norway, but they're still being bullied to offer these stabilization clauses. So this really raises a lot of concern, the fact that even the countries that are stable politically, economically, with effective rule of law, they are still being bullied to offer stabilization clauses. So this is a big problem, and we really have to look into that. And like I mentioned previously, we are no longer in the 1970s. Things have progressed, countries have progressed. It's rare that you'll find a country, a host country, that will nationalize petroleum projects. And besides that, we already have the national laws to protect investors. So we already have the international laws. We already have the bilateral investment treaties. So in a sense, it's my opinion as Victoria Narley that we don't need stabilization clauses in the 21st century. And this is the point where I'm saying that most developing countries are politically stable with an effective rule of law. So why exactly would they still be offering these stabilization clauses? And also the main thing, like I mentioned earlier, these clauses make the tax, financial and commercial concessions, as well as other contractual provisions permanent for a 20, if not a 40 to 60-year period, depending on the petroleum project. So my question is, which country would not want to amend its laws after 40 years? Which country would not want to amend its laws after 60 years? Because societies are progressing, so countries should be able to make amendments accordingly. Then what is the way forward? First, it's still my opinion as Victoria Nolly, where possible, developing countries should stop offering stabilization clauses in the 21st century. And that is based on the reasons I've given you, the stability we have, because it's no longer an issue of instability. Most of these countries are stable, so there's no need for be bullied into offering stabilization clauses. But however, if it's impossible to really not offer these stabilization clauses, then host states should limit the coverage and time frame for these stabilization clauses. Time frame, it shouldn't be 40 years or 60 years, or even 20 years. They should be able to react to the changes. I'll give an example. Last time I gave the example of Norway. At first, they were offering these stabilization clauses, but it was for a very limited period of time, in that the moment they started development, they actually changed some of the terms of the contract. So if Norway was able to do that, then why are developing countries in the 21st century still offering stabilization clauses of 60 years? It is not acceptable, and we should not be taking that kind of direction in the 21st century. And then the other thing, what host governments should do, obviously they need to ensure rule of law. They should strengthen their legal and regulatory framework, because we have to imitate what these developed countries have done to be able to get away with not offering stabilization clauses. And it's mostly due to the stability in their legal and regulatory framework. So if we can ensure stability in the legal and regulatory framework, then there would be no reason to offer a stabilization clause of 60 or even 40 years. And for the international oil companies, there are other avenues of protecting their investments, because history shows that the presence of a stabilization clause in a petroleum contract, it doesn't mean that the state will not take any actions that are likely to be detrimental to the investments of these international oil companies. Like I'm going to show you in the case of Libya, they had a stabilization clause, but they still nationalized the property. So the presence of a stabilization clause doesn't mean that the state, the investors are protected unilaterally. So in this respect, the international oil companies should embrace other avenues of protecting their investments, including the national investment laws, as I'll be outlining, regional energy laws. In the ECOWAS region, they have the 2013 ECOWAS protocol, which is similar to the Energy Charter Treaty. And then the bilateral investment treaties, like Peter mentioned, many countries have signed many BITs. So why exactly do we still have all these forms of protecting investments, and then we're still clinging on stabilization clauses? So although I've mentioned the issue of BITs and MITs, I just need to note some of the practical issues that have been associated with these BITs, especially in developing countries. For instance, in South Africa in 2010, in July 2010, after they had the reviews of their BITs, they recognized that most of these BITs were not they were not benefiting the South African government and the South African people. So after the reviews, they realized that most of the BITs were negotiated at a time where the negotiators didn't have expert knowledge about the contracts they were negotiating or the treaties they were negotiating. And in a sense, it ended up that the BITs were mostly benefiting the other countries they had negotiated with. So even with the BITs, it is my opinion that developing countries should be careful with the provisions of these BITs. Because South Africa is a good example. They had to cancel many BITs which they had entered into with European countries. And then for the multilateral investment treaties, we have the example of the Energy Charter Treaty. And I'm sure most of you might be aware that the treaty was modernized in 2015. At that time, I was also working in Brussels at the Energy Charter Secretariat. But also with the BITs, countries have to be taking into consideration what exactly are they negotiating. Because in the past, developing countries have been negotiating or entering into BITs, MITs, signing contracts that are detrimental to their people. So in the 21st century, we're not expecting that. We're expecting to have a level playing field whereby if the same principles, if the international oil company is applying certain principles in the developed world, they should apply the same principles in the developing world. Obviously, with respect to issues of investment, there are already laws to protect investors, all kinds of investments. So it shouldn't be discrimination. It shouldn't discriminate against certain types of investors. I talked about the national investment laws, and still I'll give the example of South Africa. After realizing that most of the BITs they had negotiated were detrimental to their people, they decided to embrace national investment laws, as all countries should be doing. And in that effect, the 2015 Promotion and Protection of Investment Act came into force. And under Section 4 of that act, it basically protects all kinds of investments. But what really stands out is Section 4, Clause B, which says that it affirms the Republic's sovereign right to regulate investments in the public interest. This is very important because you notice that with the stabilization clauses, if you're to interpret them strictly, they will not affirm to this clause 4B, where the country should have the sovereign right to regulate investments in the public interest. So this is an issue for those who are interested really in negotiations, in investment laws, investment protection. This is an issue that you should really look out for. Then I talked about the Libyan case, but my focus here, I want to highlight the aspects of state sovereignty, because like I mentioned, in most cases, countries negotiate these contracts when they are not ready. In South Africa, one of the reasons they give in canceling their BITs is that at the time of negotiating those BITs, the negotiators didn't have the expert knowledge, the experience, and in effect, they ended up negotiating terms which were detrimental to their people. Now, my question is, how many mistakes do you think developing countries have made in the past 40 years when they were negotiating these petroleum contracts? Very many mistakes because of lack of expertise and maybe lack of expertise, and also maybe most of them were not suited to negotiate those contracts. And also the fact that people change, that various changes that come around with in different countries. So if you have a stabilization clause, you cannot insert that at the time the clauses were negotiated. Maybe people were not well equipped to negotiate those clauses, because they will still apply to the country. And the Libyan example is really evidence of that. I'll just read it for you. It's the case of Texaco Overseas Petroleum Company and the California Asiatic Oil Company versus the government of the Libyan Arab Republic. So in this case, with respect to the concept of sovereignty, the key issue was whether a state can disregard its international commitments assumed by it within the framework of its sovereignty. In other words, can states bind themselves by contract? That was the main question. The arbitrator decided that a state may contract not to exercise its power of nationalization at all in respect of a particular enterprise for a limited period of time. In essence, the state can bind itself by contract. Professor Rennie held that the undoubted right of a state to nationalize could not prevail over a stabilization clause in the contract between the state and the foreign private investor, and was therefore illegal per se, regardless of the issue of compensation. So this case basically brings in the issue of state sovereignty. So it doesn't matter how the state reacts, as long as you have a stabilization clause and you do anything detrimental to that stabilization clause, the state will have to be liable for compensation in instances of arbitration when they're taken to arbitration. So in closing, my opinion is most of the national laws, national investment laws, the BITs we have signed, the MITs we have signed, they all protect investments, all kinds of investments. So it doesn't matter if it's a petroleum investment, or if it's investment in farming, all kinds of investments are protected. And in that respect, that protection is enough for the international oil companies. Countries should not go further to offer stabilization clauses, because this is not standard in all countries, and it's not. It doesn't mean that if you have a stabilization clause, a state would not do anything detrimental to the investments of the international oil company, because this Libyan case, they had a stabilization clause, but still the country went ahead to nationalize resources. So the main message for me that I'm giving out is for the countries to strengthen their legal and regulatory framework, strengthen their national laws, and also with respect to the BITs, let us not rush into signing BITs we do not understand that will be detrimental to the country, to the local people. I think in the 21st century, we should have a level playing field where we negotiate contracts that will impact positively to the investor, to the host country, and also to the local people. So that is my message for me with respect to stabilization clauses. They have no place in the 21st century because we have strong legal and regulatory framework. We are stable politically. Most of the countries are stable. So stabilization clauses should have no place in the 21st century. So that's my presentation. We're going to go in Q&A. I don't know if you have any questions here.
Victoria, how long are you planning to go for?
I think the Q&A we can use like 5 minutes. I know we are past time. I don't see any questions any from the people, but I'll ask. All right. All right, I don't see any questions so far, but I'll go to you, Peter. So in your experience after all the presentations, in your experience as a practitioner at Uganda National Oil Company, what do you think should be the way forward for developing countries like Uganda? Do you think they have strengthened their rule of law and their legal and regulatory framework? Do you think they still need to rely on stabilization clauses? Or what can they do to ensure that investors are protected? And as you're answering, I'll look out for questions to Dr. Carol Nakla.
Excellent. Thank you, Victoria. Thank you, Carol. It's always a pleasure to touch base with you. I've interacted with you and worked with you for a while. I've read your books, and it's always good to talk to you, and very good presentations, both. I think I would put this in a few questions, and you touched on some. There is obviously a need to strengthen our laws, our institutions, and to ensure that our systems can be trusted, because investment in many cases is about perception. So as long as perception is still that we might misbehave, then these requests will come, these requests for these packages will come. But for anybody sitting on the side of government or national companies, I have a few questions that I want to put to you so that you should consider when you're looking at these requests for these packages. One is, will the investment happen in your country if this package is not offered? So you have to have a very balanced analysis of whether this investment you're looking at will take place even without a stability package. And I think juxtaposed against that, you need to ask yourself, okay, if we do not have this package in the agreements, are we likely to have successive governments who behave and respect the agreements reached by governments before to ensure that there is no unilateral changes to these contracts, and investors can be comfortable that successive governments will not wish to ride on populism and renegotiate. And these are behaviors, Victoria and Carol, that we have seen happen in some places. Not to generalize as Carol indicated, but they've happened in some places. So there are questions we need to ask ourselves and answer. If yes, then we have a good point to say stability packages are not required. The second question we ask, if we deem that we need to have these stability packages based on our analysis of how successive governments may behave, how our perception is, whether investment will happen or not without this stability package, then we need to ask ourselves, what is the stabilization package intended to address? And is it intended to cover the duration of the contract? How long should it last? What is the purpose of the stabilization clause? And if these answers are clear, we are able to determine what kind of stability package that we need. And the other question is, if you decide that stabilization clauses should be, packages should be included, can they be two-facing? Because the government may enact a law that positively or that enhances the economics of the project. What happens? Because that is the other side of stability that we do not talk about, because most of the stability packages we look at are one-way facing. They are facing the investors. They are protecting investors from any economic downturn caused by changes in the law or behavior of the government. What happens when the behavior of the government is positive and it improves the project economics? Can that equally be included in the project stability package if you deem it is necessary to give? Then the question is, I think this one is provoked by presentation from Carol and yourself, Victoria, on, I think putting it together is, are we likely to have a race to the bottom? So each country is fighting to offer the best stability package. And at the end of the day, you have a race to the bottom between countries, of course, that are already at the bottom. So we need to look at it and ask ourselves, are we trying to attract investment, allegedly, by offering better than our neighbor? And these are the questions we need to look at. Then related to what I've just talked about, how can we avoid overreach? Can we limit the stability package to the elements of the investment that need that stability, and for the time frame we need that we deem that stability is necessary, so that we do not have these overarching general provisions that cover everything? So can we avoid overreach? Can we determine when it is an overreach? And this is the question that we need to look at. And coming down to the questions, I think an issue I felt I should tackle is the possibility of negotiating a contract and holding its terms for a period of 40 years in the same terms. And there are challenges to that, largely because so many things change in 40 years. And so there should always be flexibility in mutual respect and ability to review those contracts. I do not agree that the review should be unilateral, but should there be flexibility in provision for review of those contracts under certain circumstances? Because circumstances change. And I can go through all resource nationalism cases, and it's very possible that, except a few, probably really few, that you will find that the instability within the contract precipitated the resource nationalism. So can contracts be structured like fiscal packages, where you achieve the ability to reap a return, but also create stability in flexibility, or stability that is based on flexibility within the contract to make it mutually beneficial in its term? And with that, Victoria, I'll hand back to you and hope I've answered your question. But of course, there's an issue of capability of nations. We have a report at the AU that was handled by Mbeki, former president of South Africa, that highlighted losses in revenue that Africa has suffered due to poorly negotiated contracts. And that is not for the investors to be blamed, but it's a challenge that based on imbalance in capabilities and advisory services available during the negotiations of these contracts, there might be results in the contracts that are unfair, to say the word. Of course, it's difficult to determine what's unfair, but that would cause leakage from countries and precipitate nationalism. So is it possible to create an obligation that at the negotiation point, the international investor has the obligation, financial, to ensure that governments negotiate competently? And that's a good question to look at. Or can the governments themselves build the capacity, hire advisors to ensure that at the point of negotiation, the terms entered into are well balanced in terms of risk allocation, benefit allocation, obligation allocation, and all these matters to avoid what stability packages really intend to protect. Thank you.
All right, thank you very much. Sorry, we've run out of time. Carol, would you like to give your concluding remarks, and then that will be the end of our webinar, since we don't even have many questions. And sorry about the time.
Yeah, thank you, Victoria. I'll just make a couple of points. It's important, you see, it's not about taking sides, and here I have to disagree with you, Victoria, that I don't have a strong sentiment against stabilization provisions. Of course, it's all at the end depends on how they are drafted, their coverage, the duration, what do they target exactly. So we cannot reach really a blanket conclusion on whether they are good or not, and whether developing countries are offering it, whereas the developed economies are not offering. I mean, and at the end, you have to be careful when you are comparing countries. Norway scores high, if not the top, occupies the top ranks on all good governance of the extractive industry. Now, if you want to compare yourself with Norway, then you want to be at least around the same ranking as Norway. That said, so that's why I say it's important to keep an open mind when it comes to stabilization provisions, and if you want to give a learned, balanced advice, you have to understand the perspective of both the government and the investors, because at the end you want to come up with a win-win situation for both, because as I said, you get one investor, you get more capital invested, etc. With respect to the second important point where I am strongly, I can tell you exactly strongly what I think about them is I don't believe they are effective. And if in terms of application, and actually many people don't realize, those who have not been actually involved in contract negotiations and renegotiations, that renegotiation of contracts happen much more frequently than many people realize. And often they don't result in arbitration because companies don't want to activate the nuclear option where they kill their future investment in the country. So they tend to sit down at the table with government officials and try to find a mutually acceptable solution. So this happens. However, the key is to avoid this altogether and have durable extractive contracts, either for oil and gas or mining. And this is why you have to be very careful to the drafting of the contract right from the start, the drafting of the fiscal regime right from the start. And I tell you, more than 20 years of experience in this area, and I'm amazed, and there's a lot of publications out there, a lot of open, free advice out there. And it's amazing how much governments tend to resist regimes which can offer a durable, lasting solution without the need to offering any stabilization provisions.
All right, thank you very much, Carol. Thank you very much, Peter. So this marks the end of our webinar, but like I mentioned, it's not that I'm against stabilization clauses, but my argument is there are other avenues of protecting investments, and the presence of a stabilization clause is no guarantee that the investments will be protected, as we have evidenced in various arbitration cases. So the issue is to really be careful on what countries are negotiating, and also ensure that we apply the same standards everywhere, especially in countries that are stable politically socially, and also with respect to the legal and regulatory framework, was the key issue is good governance, rule of law, and stable legal and regulatory framework. And if a country has that, then there's no need to go into stabilization clauses. That is my opinion, of course. So this marks the end of our webinar. We shall share the presentations with you. And thank you very much, Peter. Thank you very much, Carol. And thank you very much, our participants. Have a lovely day. Bye-bye.
Thank you, Victoria. Thank you, Peter. Bye-bye.
Bye, everyone. Have a nice evening.